now we are going to go into our questions for today. It looks like we have about 20 questions right now, so I'm just going to start right with them. Our first question is, a member of our community believes that a marriage automatically entitles their spouse to membership within the community. The home is currently titled as a single person in a trust. My understanding is only titled persons are members. What is your opinion on this? I can't find anything definitive about what the laws are on this subject. So short answer would be look at your association's documents. Typically, a member of the association has to be a record owner, and a record owner would be the person listed on the deed. A trust is a little different because I don't know if that person has been added, like the spouse has been added to the trust, so maybe they might have some rights as a member. But if it's a recent marriage and the trust has already been in place, it's kind of unlikely that that would be the case. But so check your documents. Usually you have to be a record owner to be a member of the association. Okay, next question. Is it unlawful for an HOA board to provide a proposed CC&R amendment to a future homeowner? Oh, good question. So oftentimes you have buyers who are thinking about moving into your association and they ask for information in advance of, purchasing. And the association has no obligation to provide records to a buyer. We only have an obligation to provide records to an owner. And so if you get a request like that, what I would recommend is have the buyer make the request through the owner, because that's who we're contractually obligated to respond to. So is it unlawful for the association to provide the board with this? It's not unlawful, but it's unusual, and it's not something that is a precedent I think that the board should be setting. The owners are the only ones that are entitled to see books and records of the association. And if the owner chooses to share that information with the buyer, great. Okay, next question from an owner. We have a parking restriction of no parking after 4 p.m. When residents ask why, they say it is city, street, code, or law. I Googled it and cannot find anything on the subject. I would like to know if there is a city code or law on no street parking in a residential area after 4 p.m. or any other time. Because I don't know which association you live in, and I don't know where it's located, I really can't answer that question. The best thing that you could do is contact your city, maybe even your code enforcement department, and ask them that question for your city, town, or municipality that you live in. Okay, next question, number 4. We had a potentially dangerous incident last weekend between a non-resident and a resident owner, as the non-resident and his 2 large off-leash dogs visited one of our private grassy parks. The resident approached the non-resident and informed him that dogs need to be on a leash at all times. The non-resident berated the resident, saying at the end, "I know where you live." The resident was able to take a pretty good picture of the man and his dogs. We have at least one other report of a man and unleashed dogs matching the descriptions in the park. What are our options for keeping this particular person off the association's property, including the streets? Like a restraining order? Is that an order? Okay, so if you have somebody who doesn't live in your association and they are trespassing in your private park, you can contact the police because they're trespassing. You may want to put up no trespassing signs just so it's clear that this is private property. But if something like this happens again, I would contact the police to have that person removed. I think it's important that you have the no trespassing signs. And I think it's important to find out, hey, is this resident like a guest of an owner or another resident? Or excuse me, is this non-resident a guest, or are they have any special right to be there? If they are a guest of an owner or a resident, then we can fine the owner for the non-resident dogs being on the property and being unleashed. I think the first line of defense on this would be contact the police. I would prefer if you had no trespassing signs that are visibly posted. And if this non-resident is somehow associated with a resident or an owner, making sure that that owner or the resident knows that they're responsible for the behavior of this non-owner. Okay, next question, number 5. A member of the community is challenging whether an owner can display a political sign on their property not near an election. Our CC&Rs do not specify dates. ARS 33-1808, which is referred to in our CC&Rs, does define the date windows when signs are allowed and says we may prohibit political signs outside the date windows defined in the statute. Does this mean we can, as a board, prohibit the signs without adding that to our CC&Rs, or do we need to add the date windows to the CC&Rs? So the date windows that are in Arizona Revised Statutes 33-1808, those are state law. So the owners need to comply with those. And no, I don't have on the tip of my tongue right now the actual, dates in advance. I think it's, I know the sign has to be down 3 days after an election. I believe is what it's changed to now. And so somebody having a political sign up right now is beyond the time period. Now, I don't know if you have any elections that are going on in your neighborhood, because remember, you're allowed to have signs for anything pertaining to your association, political signs. So I don't know if there's a ballot initiative that's currently being voted on. They could have a sign for that. I don't know if your city, state, municipality has something right now that's being voted on. And so maybe you're within that time period. I doubt it, but so answer your question, can we prohibit it, based upon the statute? Yes, my opinion is you can. Okay, next question, number 6. We are a condo association and one of our owners passed away. The son is listed on a beneficiary deed and he is under 55. His wife will be 55 shortly and has moved her son and girlfriend into the condo. They are not over 55. There is no other adult living there, 55 or otherwise. The son's wife say they will be moving in, but there is reason to believe that it is not going to be the case. They will not fill out an occupancy form. What steps do we take to nip this in the bud? I really think the best way to handle this is, just so quick update on this. The son, because the owner passed and the son is listed as the beneficiary on the beneficiary deed, the son is now the owner. The son is not 55. And so that he can own it, but he can't live there unless he's living there with somebody who is 55 or over. And so what steps do we take to nip this in the bud? It looks like they've got, family members moving in. Nobody's over 55 or over. I think have your attorney or have our firm write them a letter and just outline what the law says. This is what the CC&R say. And whoever's living there has to fill out an occupancy form. And by the way, at least one person has to be age 55 or over residing in the property. Okay, next question. This year, our statutory agent, the owner of the HOA management company, did not sign our tax returns. This was always done in the past. A board member had to sign. Is this a red flag? Honestly, I think the board member should be signing the tax return and not the president of the management company. So it's not a red flag at all. And this situation might be directly related to the fact that maybe there was a change in the ownership of the management company and the new owner knows that, hey, I can't sign this because I'm not a director of the association. A director of the association needs to sign the association's tax returns. Okay, question number 8. Can a vendor put a mechanics lien on an association's common area for non-payment of an invoice? The vendor did not appear to perform the services and replace parts as it was invoiced. The board withheld payment, although eventually paid and just fired the vendor. So yes, there is such a thing as a mechanics lien in Arizona. There's a whole process that the contractor would have to follow in order for that to be a valid mechanics lien. So short answer is yes, but obviously they would have to perform the work in order to be paid. Okay, question number 9. Does an architectural review committee rule need some grounding in the CC&Rs? So, it just depends. It depends on how broad the rulemaking authority is in the CC&Rs. And obviously rules cannot conflict with CC&Rs. So I hope that answers your question. Number 10, regarding the capital improvement fee per 33-442. A capital improvement fee cannot be paid to a third party and must touch the land. Can you clarify what this means? For example, Can we pay a third party to remove plants or trees using these funds? Okay, great question. We have a cheat sheet on this topic, which would be very helpful for you to best understand what a transfer fee or a capital contribution fee is. So I would encourage you to go to our website at mulcahylawfirm.com, go to our cheat sheet section on our homepage. It's a drop-down tab, and type in transfer fees, and you will see our cheat sheet will pop right up. Okay, so bottom line is there's a state statute that defines how transfer fees or capital contribution fees can be, in place by an association. It has to be a CC&R amendment. It has to be payable to the association for a specified purpose. And so that's typically the language. Money is typically segregated into a separate account. So can we use the money to remove plants and trees? I mean, I don't know. I don't know how the money is defined as being used in your CC&Rs. So you would have to let me read it before I could tell you if you could do that. But typically, removing plants and trees would not be something that is typically used for like a capital contribution fee. Typically, it's going to be something, for long-term capital improvements in the association. That's how we fund, capital, improvement, type projects, or this is not going to be just like general maintenance type things, which general maintenance is removing trees and plants typically with association funds. That would usually be, out of not like a special capital contribution fund. That would just be out of the general fund for the association typically. Okay, question number 11. Our HOA board members have called homeowners out to fight in the parking lot, and have publicly named and shamed owners for being behind on fees during meetings. Is this legal? How can we remove these board members? Okay, so I would say this sounds like unprofessional behavior if this is true. There should be no fighting in the parking lot. There shouldn't be any name calling and shaming of people that are behind on assessments or money owed to the association at a meeting. I think that subjects the association to a lot of liability, and I'm concerned by what you've told me here. So is this legal? Probably not. If they're, it could be considered a breach of fiduciary duty to the corporation. How do we remove these board members? We have a whole process under Arizona law to remove board members from office. You can go to our cheat sheet on the top 10 things you need to know about Arizona law. And one of our number 6 on the cheat sheet is the process under Arizona law to remove a director from office. And it's kind of like you have to have a petition that's signed by a requisite number of owners, and then you have a special meeting of the membership. And at that special meeting of the membership, you have to have a quorum of 20% of the homeowners. Then you have to have 51% of a quorum to actually remove the directors from office. Okay, question number 12. I found out that our board has been filing IRS 990 forms with false or wrong information since 2005. If the IRS finds us, can the association members force the board member who signed the form to reimburse the association? I mean, I don't know enough about, I'm not a CPA, so this would probably be the best question for a CPA. My experience is I've never seen a HOA board member, be fined or have to reimburse the association for maybe a mistake that's made on something like this, like a tax form. These types of things are usually easily fixed, or you just start filing it the right way going forward. So I don't think, that's something that you would be requiring the board member to reimburse the association for if a fine was levied. Okay, question number 13. We have an owner or investor that owns 20 units within our community. When it comes time for voting for the annual meeting, this person has a lot of power to vote on who they want to get on the board, including themselves. What can we do to limit this kind of power control in the future? Or should there be a limit control of units what person can own within a community? My suspicion is that this person wants to raise HOA monthly dues to drive people out so they can purchase more units here. Well, a couple things. I mean, people have a right to buy property. And so, yes, because they own so many units within your community, they do have a voting block that allows them to, make a difference in issues that pertain to the association. I have seen some associations implement, a restriction saying that, you can't own more than a certain number of units. I mean, obviously you wouldn't be able to go backwards. You would just do that going forward. Like with the grandfather clause for them, it's possible that you could do that. You may want to reach out to our firm if you, want to consider something like that, but you're going to have to look at the numbers. Like, can you even pass this proposed language knowing that they own 20 units, because they're going to vote against it? So we want to be practical. So I'd probably want to look at all facts, in terms of how many lots are out there, units, and, if this 20 unit block doesn't vote yes, is it even possible for us to have this move forward? Okay, question number 14. At our February meeting, the board approved the lowest of 3 pool parking lot bids, but didn't disclose the companies. When I requested copies of all bids, I only received part of the approved bid after several reminders. The board president later said they don't have to provide the 2 other bids. Is that correct? My feeling is if it was a book and record of the association, it needed to be provided through a records request. Okay, next question. Hello, I'm managing a community where, before I started, a board member bypassed the association's attorney and made a direct payment arrangement with an owner who was in collections. The attorney is understandably frustrated and wants to review the agreement for validity and to determine if attorney's fees can still be pursued. Is there any issue with sharing the signed agreement between the board member and the owner with the association's attorney? I don't have any problem with that. Your attorney is a member of your team, and I think that I would run it by the board, make sure that the board's okay with you giving it to the attorney. And I do understand that the attorney is frustrated because if the owner was in, that attorney's office and maybe all the fees aren't being collected, somebody's not going to get paid here. So the association or the attorney, so they're probably concerned about it. So check with your board to make sure that they're okay of you giving it to the attorney, and you're welcome to say to your board that, hey, I asked this question at a seminar and they said there aren't any legal prohibitions for us providing it to our attorney. Okay, question number 16. Are property management companies registered on the Arizona Register of Contractors website? No, they are not. Management companies are not regulated by the state of Arizona, and there is no Arizona enforcement arm that, manages them or has any penalties for them if they make mistakes. Okay, next question, number 17. Our HOA selected a contractor for full irrigation system replacement, but the manager didn't have a loan secured. 6 months later, we're still seeking member approval for the loan, and I'm concerned the chosen contractor may not be the best option anymore. Are we still obligated to use this contractor? What options do we have, and should we consult our attorney? So I guess I would want to know more about our HOA selected the contractor. Like, is there a written contract? Was this just like a verbal? What has your communication been with the contractor? And I mean, if it's just a verbal, it's probably not enforceable. But if there's a written contract that obligates both sides of the equation here, the contractor and the association, it likely is enforceable. So you definitely want to reach out to our firm or your attorney and ask these important questions so you can determine what your rights are. Okay, question number 18. Does only the board decide on whether or not to have a full management company? Should this have been put up for a vote by the homeowners? Our management company will not reply to homeowners, only to board members. Okay, let's see. So does only the board decide? So yes, the board typically makes a decision on whether to have self-management or a full-time management company. Unless it's in your documents requiring that particular situation be voted on by the homeowners. And I think I rarely see something like that in CC&Rs or bylaws. 99% of the time, the board makes a decision to hire or not hire a management company. You're saying your management company is not replying to homeowners and only replies to board members. And, I'm guessing that's why you're concerned about the management company. They're not doing their job. So I would say reach out to your board and let them know that, hey, the management company isn't doing their job. They're not responding to homeowners. Maybe ask for a copy of the management company contract. Maybe it's accounting only and they're not required to respond to owners. So do a little more due diligence on that and talk with your board about it. Question number 19, please talk about a transition fee sought by the potential new management company. Okay, a transition fee is a little bit different. Basically, it's in the contract that's between the board and the management company, and it's just like it's in the contract that you sign with the management company. And I'm seeing that more and more with management companies, especially with some of these out-of-state management companies coming into Arizona and buying up Arizona, traditionally Arizona homegrown management companies. And so basically, if my association is hiring a new management company, in order for them to get all set up, they may charge a transition fee of $500 or $1,500 or $2,000. But it's in the contract between the new management company and the association. So it's something that can be negotiated. But I find if the management company that's being hired puts that in there, they want it because they want to spend the time to, move the management company, from the old management company to the new management company. It does take some time to do that. And so that is a fee that I'm seeing more and more. For smaller associations, typically that's not being charged. It's usually being charged for like associations that are 200 lots or units plus. Okay, question 20. I manage a community. They have a beautification committee. This was working great, but then 3 members of this committee joined the board, making them the majority, and this has caused issues with the open meeting laws. They are approving to spend money on things that are not in the best interests of the entire community. They're attempting to change capital items without proper community approval. How do we address this in a way that is respectful, but follows the legal process to keep them from getting into trouble? This is a really good question. So you're the manager, the board has changed, and now they're potentially not following the law. They're not acting in the best interest of the community, in your opinion. And how do we handle this? So I think I would respectfully remind them at meetings that, hey, this is a violation of X, or this is something that's not consistent with your documents, or you're violating state law by doing this. If they don't listen, then you may want to have the association's attorney come in and do a boot camp for the board and talk about, Arizona laws that they need to be aware of. And, in advance, you could tell the attorney, hey, these are some of my concerns, and maybe the attorney can rewrite that into the script for the meeting so that the board finds out from an independent third party that, hey, these are some issues that need to be addressed. Okay, question number 21. Our board has 5 members that have been on the board for over 8 years. There's 1 member who's retired and lives on the property. He chooses the vendors without any vetting. How do I approach this during an open meeting? So 5-member board, 1 member, is kind of making all the decisions on vendors. I think I would I don't know if you're on the board or if you're a homeowner, because you didn't indicate that, but I would say at an open board meeting, just express your concerns and just say, I'm concerned that one person is making decisions on these things, and this really needs to be a vote by a majority of the board at an open board meeting. Okay, we are on question 22. I'm just going to do a quick check to see how many total questions we have. We have 28, so we're moving right along on our questions. Okay, next question. Who exactly is in charge of researching and selecting a new management company? Especially if no one on the board wants or has time to invest in the process. And is it okay to discuss with other board members outside of an open board meeting, especially if the current management company is still involved in running the open meetings? So great question. So if your board doesn't have time to invest in the process of selecting a management company and researching a management company, your law firm may be willing to help you on this. I know our firm handles the entire process from A to Z for a board. And the board just comes in at the end and, does a high level, executive meeting at the end and interviews the candidates. That's one way to handle it. Can we talk about this situation outside of a board meeting? As long as it's less than a quorum, yes, you can discuss these matters outside of an open board meeting. If it's a quorum, it needs to be done during an open board meeting. If you're talking about the performance of the existing management company, you could do that in the executive session. of your board, and you could ask the manager to step out if you don't want the manager to hear your discussion. Okay, are there any tells that a family-owned local management company might be preparing to sell to a larger corporate out-of-state management company? Like change in management software. I think there definitely are some tells. Well, first you can ask me because I've been around for a long time, and so I can tell you, what I hear, in the industry about things. But yes, definitely changing the management software, a letter saying that now we're affiliated with a management company by a different name, a change in leadership in the company is definitely a warning sign. I think all of those are good indicators that there's been a change in the ownership in the company. Okay, question number 24. Our management company for the board sends out an email blast with the meeting agenda and posts the agenda on the community bulletin board. The agenda was changed on the bulletin board and was not revised and sent to the owners in an email blast. Is this legal? Yes, it is, because just putting it on the bulletin board is enough under Arizona law to meet the notice requirements. Obviously, I would try to do both. If you send it out, by email blast and then the bulletin board, if you're changing it on one, you should make best efforts to change it on the other one too. We have homeowners that have requested to install permanent lights along their roof line. Our documents were written in 1999, so they do not address this. It just says lights should be screened and shielded to not create a glare and illuminate more than 1 foot candle power. What are some common guidelines for permanent lighting? I don't really have any, common guidelines. I mean, I don't know if you're meaning like installing permanent lights along the roof line, like Christmas lights. That typically would not be allowed for 12 months of the year, but maybe down lighting so it lights up the house, that may be allowed. I think you just have to look at things on a case-by-case basis. That likely is an architectural change that would need board approval. Okay, question 26. A group of dissenting HOA members went to organize and utilize community building bulletin boards to display a Facebook group page. This group of dissenting HOA members, want bulletin boards to talk about an alternate Facebook group. Can the board prohibit the posting of the group page address based upon lack of control of potential profane or objectionable language found at the private community group page on Facebook? I don't think that the association, under the way that the law is currently written, would be required to, post this alternate Facebook page. Now, if the group wanted to get together and meet on common areas, they would have to allow that. But I don't think they have to do this, post anything on the bulletin board about this alternate, Facebook group. Last 2 questions. Are you aware of any limitations of water use in public areas from the state, like stop watering grass and trees, cutting down trees and bushes, that HOAs have been given? Has the state put out a law saying HOAs need to reduce water usage to 20%? So we have a great cheat sheet on this topic on water conservation strategies and rebate opportunities. The state of Arizona is in a water conservation stage right now, and if your association, if it applied to you, you would be receiving notification on it. So I would encourage you to take a look at these 2 blog articles that we've written, because I think those will be helpful for you. And you also definitely want to check with the state to see if your association, if any of these things may apply to your association. Okay, last question for today is, can a board charge interest on past due assessments? So it really just depends on what your CC&Rs say. If your CC&Rs allow you to do that, you can. In my experience, even if your CC&Rs allow you to do it, most associations don't, because it's really difficult to compute with the management company's software programs. Okay, that's it for today. Wow, we're right on target here. Just some concluding remarks for today. Don't forget that we have a number of other learning opportunities in April this month. On April 16th, which is tomorrow, we have a class with the city of Chandler. And then again on April 23rd, another class with the City of Chandler HOA Academy from 4 o'clock to 5:30 p.m. on Zoom. You can check out the topics for those classes and sign up for them by going to our webpage at mulcahylawfirm.com. So 2 more live opportunities to hear our firm speak on different topics this week and then next week. And it's free as well. I don't believe that you have to be with the City of Chandler to join these classes. So if you're interested, go to our website and sign up. Let's look forward to May. We have several learning opportunities in May of 2025. The first one is our live virtual First Friday event, which is the first Friday of May 2nd at 9 a.m., where I hop online and answer questions. Typically we get about 50 or 60 questions and we answer all of them in about an hour and a half. So you're welcome to submit your questions via our website. We also have in May a virtual HOA Academy, just like today. It's our monthly one, the 3rd Tuesday of every month, which is Tuesday, May 20th at 11 a.m. And this is going to be a really important class for board members. It's on board excellence. Everything you need to know about being a board member. What are your roles? What are your responsibilities? How do you get in trouble by making, mistakes? How can you avoid making those mistakes? A board member code of conduct, is it a good idea to adopt? So we're really going to be talking about everything related to being on the board. What are your responsibilities? How can you hit the tripwires and make mistakes, and how to have a successful one? Is a code of conduct a good idea? We're going to be covering all of that on Tuesday, May 20th. And then last but not least, we have a summit with the Surprise HOA Summit. And that's going to be Wednesday, May 21st at 6 p.m. You can check out our website for more information on that as well. Okay, thanks everybody for being here today. I hope that everybody has a wonderful Easter and you're already having a wonderful Passover this week. Thank you so much for being here today and caring about your communities. Take care, everybody. Happy Easter, happy Passover.